We're actually missing one of our committee members, but we're going to get started so we don't get too far behind, and he'll, I'm sure, join us in just a minute. We are now on our last panel for this afternoon. It's views from a mixed panel, and we have with us here today Judge John Carroll from Cumberland School of Law, Stanford University, George Kendall, Director of Public Service Initiative from Squire Patton Boggs, Professor Norm Lefstein, Professor of Law and Dean Emeritus, Robert H. McKinney School of Law, Indiana University, and Andrew Zazu, Chief Case Management Systems Office from the Administrative Office of the United States Courts. Good afternoon, everyone. Thank you for being here. And before we get started, let me just tell you, if you haven't heard how we function, brief opening statement to give everybody the opportunity to sort of give us an overview, but we have received your written statements, we've reviewed those, and then we really like to have the opportunity to ask you questions. So we'll start with the brief opening statements, and we'll start with you, Professor Lefstein.
Thank you very much, Judge Cardone, and thank you for the opportunity to visit with you this afternoon about the Criminal Justice Act. As you indicated, I submitted a statement to the committee, and I think I'll just make a few comments based on the statement. First, as I indicated in my statement, my background is different than most of your other witnesses because my primary preoccupation, literally for decades, has been defense systems in state courts. And in that connection, I've worked on standards for the ABA, and I have studied the subject in a number of different states, and I've written about it extensively, including a national report that was issued in 2009 by the Constitution Project on behalf of a National Right to Counsel Committee that looked at all of the problems in indigent defense in state courts. I have had some involvement with federal defenders and with the Criminal Justice Act. I was on the board of a community defender program in Indianapolis, a founding member of that board. And I also headed up, at the request of the Defender Services Office, a study of the cost and quality of death penalty representation back in the 1990s. Which I think was often referred to as the Spencer Report, and that I think your reporter, John Gould, was involved in the successive report. And I also was involved many years ago in helping to develop the DC Public Defender Service and participated in writing the statute for that program, which is often cited, and I know has been cited in your testimony, as a model state defender program, but of course it only serves the District of Columbia. I appeared before the Prado Committee back in the early 1990s, and I don't have any specific recollection of what I said. But
we do.
But I see Judge Prado is here, and I shouldn't.
You want me to recite it back to you?
I would be very impressed if you could do that. But I do feel certain I said things before the Prado Committee that are similar to what I said in my statement about the need for independence, which of course was adopted by the Prado Committee. But one of the points that I made in my statement related to the fact that this is not a new idea of the American Bar Association, which has been at the forefront of developing standards for defense services in the United States. The first edition of standards for providing defense services, which were published in 1968, made it very clear that those who furnish indigent defense representation should be subject to judicial supervision only in the same manner and to the same extent as are lawyers in private practice. And now, more than 50 years since the Galt decision, and almost 50 years since those words were written, we're still in search of that proposition, both in the federal courts and, unfortunately, in many state courts as well. But that concept has been repeatedly embraced by organization after organization, a National Advisory Commission on Criminal Justice Standards and Goals back in 1973. The report that I referred to had a number of recommendations published in 2009, and there are others. And of course, the idea of independence is the first principle of the ABA 10 principles, which, as I said in my statement, is simply a distillation of policy positions that the ABA has long adopted. But we made it the first principle, and I worked on these as well. We made it the first principle of the ABA 10 principles because we thought it was imperative in order to have a fully successful system that the selection and funding and payment of counsel be independent. Independent both of political forces, but also independent of the judiciary. And as I indicated in my statement, in 1968, when those first standards were developed, the chair of the advisory committee that was reviewing those standards was the late Chief Justice Warren Burger, who was then a judge of the D.C. Circuit, and there were two other judges, circuit court judges, who were on that ABA advisory committee at the time, as well as professors and prosecutors and defense lawyers. In my statement, I also addressed the actual independence of the defense function in state courts. And among my comments, I said, there are few states in the country, if any, in which the state's judiciary has the kind of total control over the delivery of defense services that the federal judiciary has over the federal defense program. And it's a control that has existed since the inception of this program. And many of the problems and issues that have been cited to this committee in testimony and in the hearings you have held, and I've gone back and reviewed statements and I've listened to some of the tapes, all of them seemingly, or at least I can say the vast majority of them, are attributable to the judicial control that the federal judiciary has. And I said in my statement as well that this really constitutes a conflict of interest for the federal judiciary by analogy to Rule 1.7 of the Rules of Professional Conduct, and indeed the very decision-making of the federal judiciary in deciding whether or not to retain that control is in and of itself inherently a conflict of interest. And I also, in my statement, talked about...
Could I ask you to wrap it up pretty quickly so we could hear short statements from everybody?
Oh, I'm sorry. If I'm going too long, I will be very happy to
Yeah, it's because
conclude.
we want to get to the questions.
That's fine. I apologize for being longer. I did not time this, and I appreciate your time constraints. Thank you very much.
Okay. Judge Carroll.
First of all, I very much appreciate the important work this committee is doing and your accommodation of my schedule. I was scheduled to be with you all in Birmingham, which is my home, but I appreciate the opportunity to visit Minneapolis. What I want to talk about this afternoon is the importance of coordinating between the state and federal proceedings, the capital habeas units. And I come at this issue from a wide variety of perspectives. First, as a lawyer who has represented people charged with capital crimes, represented them at trial, on appeal, and in post-conviction, I come at it from the standpoint of a magistrate judge who rules on habeas corpus petitions, and I've ruled on death penalty habeas corpus petitions before. I think the core problem, though, was created when the AEDPA was enacted, which is the AEDPA essentially shifted the responsibility for federal criminal constitutional procedure decision-making from the federal court system to the state court system. And so what does that mean? That means effectively that if you do not absolutely perfectly litigate the issue in state post-conviction, then you have lost whatever opportunity you may have to litigate it in federal habeas corpus. So while the capital habeas units are very, very important entities, they cannot function unless in state court they have good counsel to make sure that the issues are raised in an appropriate way. Take, for example, an ineffective assistance of counsel claim. In most states, under the procedural default rules, if an ineffective assistance of counsel claim is not raised exactly right, then the claim is defaulted, which means that when you get to the federal court system, federal court can't reach the merits. Even if it's not defaulted, the new rules about how the evidence has to be presented, that is, based on the Supreme Court decision that the evidence has to be presented in state court, how it's presented in state court, and the whole issue of the way the AEDPA structures the system of review, it's no longer whether there is a federal constitutional violation that's harmful, it's whether there's a federal constitutional violation essentially that's way, way out of line and crazy. So in order for the capital habeas units to function well, I think we've got to develop some system of an integrated approach where the federal capital habeas units have some role to play in state court litigation. Otherwise, capital habeas units can't be as fully effective as they should be and as you would want them to be.
Thank you. Mr. Zazo.
Good afternoon. My name is Andrew Zazo, and I'm the Chief of the Case Management Systems Office, Administrative Office of the Courts. My office is commonly referred to by the acronym of CMSO, and it's a new office created after the reorganization which took place in June of 2013. One of the outcomes of the reorganization was a merger of the case management functions for the Defender Services Office, Probation and Pretrial Services Office, and the Court Administration Offices. The goal for creating CMSO was to break down operational silos in the organization, leverage best practices across the judiciary, and develop a consistent way of developing and managing application development. In November 2013, I joined administrative offices after the reorganization, so I can't speak to how Defender IT was run prior to that point in time. What I can address are the goals of the reorganization, how CMSO operates today, and some of the challenges we are facing in trying to improve Defender IT services. Over the past 2 years, my organization has been dealing with many challenges as we seek to define our role with leveraging resources, not uncommon after any reorganization. Let me clearly state that CMSO does not run the servers for all courts, probation, and Defender office systems. CMSO is a software development shop that manages application development, with the exception of probation and pretrial services, for which we have an operational role in addressing service outages, and for Dismiss, which is a data warehouse system used by the Office of Defender Services. All other production operations are managed either by the Department of Technology Services within the administrative offices or the National IT Operations and Application Development Division, commonly referred to as NITOD, which is staffed by employees of the Texas Western Federal Defender Office. CMSO is not the owner of the data of any system. Data collected by any system is the responsibility of that program office or court to share or distribute. In our role as a software development office, we do not have access to production data for any office or court unless granted by that office or court. In my written testimony, I highlighted some of the issues we are addressing with Defender IT as we try to increase the value CMSO can bring to the Defender community. The work of this review committee is very, very important, and you will make recommendations which will have far-reaching effects. I felt compelled to provide written testimony and to come and answer questions from the committee so that you can have a diversity of opinion in regards to what is happening with Defender IT. That is why I'm here today, and I want to thank you for this opportunity to address the topic of information technology within the Defender community. I look forward to answering any questions you may have.
Thank you. And Mr. Kendall.
Thank you. Hi, good afternoon. Thank you, Judge. I'm George Kendall.
Can you pull the microphone towards you?
I have never been a federal defender, but I have worked with this excellent program for my entire career. I was fortunate enough in my first 4 years of practice of law in Washington to be in a jurisdiction where PDS was there. I took my share of CJA cases, little ones and big ones, and I can't tell you how important it was for me in my professional development to receive all kinds of support from that wonderful institutional defender. There was an attorney of the day. If you were in court and you had a 10-minute break and some legal question came up that you had no idea what the answer was, you could run to the phone booth, pre-cell phone days. You could call the attorney of the day and you could oftentimes have an answer. There were memos, very good memos written on new Supreme Court decisions, new Court of Appeals decisions that most of us in the private bar did not have time to analyze as quickly or as thoroughly. That service was very helpful. I went south in the mid-'80s and was doing a lot of death penalty cases. We were overwhelmed with the number of capital habeas cases where there were no lawyers. And I was one of the lawyers who came and met with the AO, then Ted Litz, and Steve Asen said, we have got a problem. There are all these cases coming into federal court, capital cases, where there are no lawyers for them. And Steve and Ted were terrific, and their work and work of some of your predecessors with the AO helped to create the resource centers, which made a world of difference. We have a new generation of those now, the capital habeas units, and I've been working some with the death penalty working group. So I've been close to this program for many years and greatly admire it. I came here, I've not submitted written testimony yet. I apologize for that. This has been a much busier spring than I'd planned. Erin, I've driven her crazy. Erin, thank you for all your leave. I was supposed to see you in Birmingham. I could not come. I was supposed to see you in Philadelphia, and so I'm glad to be here today. I want to make 3 points very quickly. First of all, on independence. I'm on the side that the program needs to be independent. I've seen in my practice both retail instances of lawyers not raising issues because they thought they would offend the judge and hurt their voucher. I ran into a recusal issue in a state case where, through investigation, I learned that the judge and the prosecutor had some kind of a very close relationship. It was an open secret in the community, but no one had ever filed a recusal motion. I said, why didn't you file a recusal motion? And the answer from every one of the very good, talented lawyers in that town were, if I file that motion, I can't work here anymore. I did not live in that town. That was the only case I had. I was able to file that recusal motion, and we got through that motion, and that judge was recused. Independence is very, very important for you to be able to do your job in these cases. I think Professor Kerr and Judge Walton raised a very good point this morning about, well, if this wonderful program does become independent, doesn't that mean there could be some real challenges to getting the kind of money that it has always gotten in the past? And I think, yes, there is that question, but I think there are things that can be done to make sure that it continues to get funding. There are, as you know, many law firms in Washington and other places that have very good lobbying offices, and I would be shocked if some of those offices wouldn't, either on a pro bono basis or in a reduced rate basis, do the lobbying for the defenders to make sure that they got their money. Secondly, I want to talk about innovation. However you tinker with the Criminal Justice Act, I would urge you to do in a way that makes the federal defenders and the community defenders much more flexible to engage in collaborative initiatives. At my private law firm, I teach a course, a 2-semester course at Columbia Law School. I have very eager students. They come with us on the road. They provide an enormous amount of help to us on our cases. It's totally free to us, and it helps our indigent clients very much. I think that there are a couple things you want to think about on a bigger scale. While the federal defender program is very good, it's also very white. It's had many successes, but it has not had great success in attracting and retaining the kind of numbers of minority lawyers that it needs to have. Many of our clients are minority. I'll never forget representing a young man in Georgia who's African American, whose crime occurred on February 1st, and he was on death row before April 1st. 57 days from arrest to death row. His 2 lawyers were white. There were race claims in that case that were never raised. It was an appalling trial. We got the case overturned in federal habeas. I went back to that community to retry that case. The same judge was there, the same prosecutor was there. And before our first hearing, my client asked me to see him in the lockup. And he said, George, you've been with me now for 10 years, but I can't sit in this courtroom again with just a white lawyer. Can you get a lawyer of color to be with you? And I'll tell you, that was a searing moment. I worked for the NAACP Legal Defense Fund at the time. We had done very good work for him, but this is something I should have recognized before he asked me. And so I would ask you to consider establishing some kind of an honors program where there's a very serious, aggressive, sustained effort to reach out, recruit, identify, recruit, train, and retain the best minority lawyers and paralegals and all that you can. And lastly, on innovation, I would urge you to think about having some kind of a scholars in residency program. There are all kinds of issues that the federal defenders, as currently constituted, do not have the time to look at in the way that it needs to. deep data searches and whatever. And I think that that would be a wonderful service to the entire federal defender system and to the state defenders, and would help in various cases for there to be more justice. Lastly, John has indicated already he wants to talk some about federal lawyers working in state courts. I would ask you to think about establishing a race initiative in the federal defender program. You read the papers recently, look at that report from the Chicago police. That's not the first time that there's been reports about how much racial bias there is in the Chicago Police Department. And I, for one, I want to be on the record, I think one of the hardest jobs one has in America is to be a police officer. It's a very tough job. But there's some bad apples in Chicago and other places, as you've seen in San Francisco, Los Angeles. Our state defender programs do not have the resources to really tackle this issue that has been a stain on our justice system forever. And it's not, those programs are not going to have the kind of resources to really tackle this. I think an initiative here that worked with some of the good NGOs, the not-for-profits who've been working on this for decades and decades, would be a terrific step forward, not simply for litigating some of these issues in the federal courts, but also where necessary to go into the state court systems and litigate those issues. Thank you.
All right, let's go ahead. We'll start with Dr. Rucker.
Thank you, Judge Cardone. Mr. Kendall, may I start with you? I'm very intrigued about your idea of recruiting minorities. Could you give us some suggestions? That's one of the things we've seen around the country is there's not a lot of minorities. We just heard about that in the previous panel as well. So what suggestions do you have for us to recruit minorities? The hourly rate's not terribly high. The work is difficult. So what suggestions do you have for us?
I think that, there are a number of things. I think you can look at what are the top 20 law schools that have significant minority? What are the top 20 law schools that have significant minority enrollment? Go in there very aggressively. Hire your summer program. Hire these first and second year law students and take a hard look at them. Encourage them to come to make a career out of being a federal defender. If there need to be initial programs, the first couple of years, certain internship programs. The Justice Department has very successfully used its honors program to attract top fight lawyers of all stripes in that program. There are ways to do this that would boost interest, both for minority lawyers to apply to the federal defender programs and to stay there. There could also be, when I was at the Legal Defense Fund, we talked about having a program where lawyers in Alabama, we didn't have an office in Alabama, could have a 1 or 2 or 3 year paid internship with a very good private lawyer doing CJA stuff. There are ways to do this. And this is a program that could do all these things. It just hasn't in the past. And I think, but for doing some of those programs, you're not going to address this problem in any meaningful way.
Let me follow up with that, if I may. Am I hearing you say then that they should work like for the federal defenders or work with panel attorneys or a combination of both?
I think you want to have a system that works in both ways, that encourages and supports and sustains in both ways. Yes.
Okay, thank you. Professor Lefstein, could I turn to you? I was very intrigued by your written submissions and the model that you proposed to us. I wondered if you could, tell me a little bit more about how you see this working, because you talk about appointments from all three branches of government. You talk about having both major political parties involved in this. Could you elaborate a little bit more about that?
Well, my idea is that you need to have diverse appointing authorities in creating a commission or a board of some kind to oversee defense services, and it's a concept that has been often repeated for state courts. If you look at the United States, there are now in states, probably 2/3 of the states have, almost 2/3 perhaps, have independent commissions that oversee public defense. The majority of those, not all of them, the majority of them have different appointing authorities, with the idea in mind that the people, once they serve on the board, don't feel beholden to the person who appointed them, and you don't concentrate power for the appointments in one individual. In thinking about this program, and admittedly, there are like 8 or 9 states where the governor makes all the appointments, and there's a few instances where you have a state director of public defense and no commission of any kind. But when I thought about this program, it seemed to me, borrowing from recommendations we've made for what states ought to do, you ought to have diverse appointing authorities from all 3 branches of government, the executive, the legislature, and the judicial branches, because defense services, I've often thought, is something in the nature of a 4th branch of government. It really isn't an executive function per se. The executive function is really prosecution. And defense services is really quite different. And I also thought that it would be good if the people were appointed by very high-level persons in the government, which led me to suggest that you ought to have the Chief Justice of the United States make appointments. You ought to have the President make appointments, and you ought to have the major parties involved in making appointments, majority and minority leaders, perhaps in the House and Senate, so that when these people are speaking on behalf of the Federal Defender Program, they really take their seats by virtue of persons in the highest levels of government. And they perhaps speak with greater authority than might otherwise be the case, recognizing that there is a concern, obviously, that defender services might not be as well funded as they are today, although I read David Patton's statement, who made a suggestion about how maybe you could tie that in some fashion to a percentage of prosecution and government funding. But that's kind of how I arrived at those suggestions.
If I may follow up with that, then how would this be applied more as we go into the districts and the appointment of panel attorneys, review of vouchers and things like that? How would that work?
Well, you may need something lower down because it's obviously a big country and a huge program. You may need that, if it was a 17-member board, to create some structures beneath the national board, or you could do it by way of legislation. But certainly you have in Massachusetts probably the premier example of a statewide program that has taken over all of the functions of providing defense services. Judges do not appoint lawyers. They do not review vouchers. All of that is handled by administrative staff of the statewide program. And it also is similar to the federal program in the sense that the majority of representation is provided by private lawyers. In Massachusetts, they're not particularly well compensated, not nearly as well as in the federal system. And the public defenders probably represent no more than 25% of the cases. That's what they're supposed to work up to. So it can be done. I mean, Massachusetts demonstrates it, and there are some other programs that demonstrate it. There's a program in California that I've studied in San Mateo County, where basically the bar was vested with authority to provide defense services, and they created a private defender program. And the judges don't appoint the lawyers. They don't compensate the lawyers. It's all handled administratively by the private defender program. And it is just as independent as it could possibly be. And you have in Massachusetts, for example, something that I don't think you have with many CJA panels. Maybe you don't have any, I don't know for certain. But the program in Massachusetts has supervisors for the panel lawyers. They have mentors for the new private lawyers. They take each year, the last time I checked, 500 files at random of private lawyers and review them. They have a task force that reviews them of other senior private lawyers, and they sometimes dismiss people from the panel because before they're put on the panel, they are qualified by ultimately the head of the program. And I understood Bill Leahy was here this morning, and that was his function when he headed that program, and he now has a successor who ultimately has that authority.
All right, thank you. Mr. Zazo, a question for you. Thank you for the detailed information you provided in your written statements. I appreciate that very much. One of the things we've heard repeatedly as we've gone around the country from the defenders and panel attorneys is they would like to see all of this taken away from the judiciary. And there's different ways they've talked about doing that. Sometimes it would be something more like the FJC or the U.S. Sentencing Commission, something like that, or else maybe a structure totally outside of the judiciary. If we were to think of a model, let's say within the judiciary but separate from the AO, how complicated would that be to shift what you're doing now to an agency like the FJC to do for the Defender Services? What kind of problems do you see with that? What kind of cost involved with that?
That's a good question. The FJC and the U.S. Sentencing Commission are not on the same network that we currently reside on, so it would have to be a whole duplication of both the authentication system that would be used as well as where would their data centers reside. Right now, the FJC, to my knowledge, does not have the data center co-located with the judiciary or the U.S. Sentencing Commission. They're completely separate entities, so that would be a duplication of cost. Again, both for standing up the physical servers as well as managing the systems. And then, of course, you have the network and authentic security on the network, too, that would have to either be copied in terms of policy but managed separately. So it would be a big cost.
I'm not trying to put you on the spot, but I'm going to anyway. Do you have any sense at all about what that might cost to put up something like that?
No. Again, I run a software development shop. I'm not into the infrastructure costs that I could tell you a number with any certainty.
Okay, thank you. Thank you, Judge Cardone.
All right. Judge Fisher.
Well, thank you all again for being here. I'm going to start with Professor Lefstein. You say you can talk.
Can you get a little closer to the microphone?
You can talk in greater detail about the problems of taking the third branch out and putting the executive branch in or an independent group in. And you also mentioned something about Louisiana's system being in crisis because it has an independent board. So if we are going to recommend going to big I independence and taking this out of the judiciary, what are some of the problems that we might not have thought of yet, and how can we avoid those?
Well, let me be clear about Louisiana. The crisis in Louisiana is not because they are independent. It's my point when I talked about Louisiana was that they are very independent. And it's precisely because they are independent that we have a crisis, in the sense that the Louisiana Public Defender Board has basically said, we can't continue like this. We can't have lawyers in New Orleans handling over 300 felony cases a year. And they developed, and I had worked on it with them, they developed a protocol for declining cases after inspecting what was going on around the state. But it was really, frankly, a tribute to the independence of the program that the crisis has received such attention, because they said, ethically we can't do it, and we can't do it consistent with the Sixth Amendment. And frankly, there is something of a standoff right now, and I think we need to stay tuned because there'll be more activity on the subject as the year progresses. I'm quite confident. And the second part of your question again was, what are the...
What can we anticipate would be the problems, even if we suggest this slightly less than perfect world where the defense function is completely outside of, either completely outside of the judiciary or a fourth branch, as you say?
Right. Well, I think, and I don't think this is an original thought, that the greatest concern would be that the funding stream not be adequate, because the federal judiciary has, notwithstanding the concerns, understandable concerns of defenders, has had a budget that has provided for the defender program. And if you look around the country, and I compare it with what goes on in the states, in many respects, the federal defender program is quite enviable. On the other hand, it is not without its problems. So I worry, like all of you, about the funding stream, which is why I think it's so important how that structure is put in place and that the people involved be high-level people who can not only speak on behalf of the program, but who will engage the appropriate lobbyists, as George Kendall suggested in his remarks. But that's really the primary issue. There is no reason, no inherent reason, why a structure that Massachusetts has developed very successfully cannot be imported to a federal program. Now, it may take more, as was suggested by your question, sir, that you may need some additional structures other than, or in addition to, the national board that oversees the defense program because of the size of the Defender program. But it is all possible. I did want to add one other thought, and I didn't say it before. There was a time when I was at the Public Defender Service in D.C. in its infancy, and I don't think this is any longer the case, when the monies that the Public Defender Service received were monies that were appropriated as part of the D.C. appropriation, the federal payment to D.C., but all of the money was turned over to the Administrative Office of U.S. Courts. And the AO basically held those monies in trust for the Public Defender Service. They had no responsibility whatsoever for the operation of the Public Defender Service, but they did provide the payment structure, the health benefits, and all of that, otherwise available to administrative office employees. And it occurred to me after I wrote my statement that you could be altogether independent, potentially, but still have, and there may be some advantages to this. I don't know enough to know for sure, but there may be some advantages in doing the same thing with the federal program that was done in the early days of the Public Defender Service, where the AO was simply a trustee of the funds and provided that administrative component because they're already doing it. And I wanted to make a point of that.
Thank you. Judge Carroll, you talked about sort of the CHOOS doing even more by integrating the process. But we don't even have CHOOS in all circuits. Do you have any suggestions as to how we can encourage that step first, assuming you think that we really should have more CHOOS than we do now?
The only way I can think of is to continue to sell how important these institutions are. I mean, if you go across the country, the representation of indigent defendants in capital cases, for the most part, is incredibly spotty. There are some places where it's good, but most places it's incredibly bad. And so federal habeas corpus really represents the only hope that a person on death row has for any sort of relief and early involvement of the federal defender. So I think emphasizing the need for capital habeas units, the value that they bring to the system is the approach that I would take.
Thank you. Mr. Zazo, you say you're correcting some of the inaccuracies that you saw, but sometimes the perception is just as important as the truth. How do we make sure that the perception that's out there is accurate? What can this committee do, or what can the AO do to better educate everyone out there in the defense function as to some of the information that you've given us so that they have all the info they need?
Well, I think part of the challenge is in getting this story out there is to show what the value is for this relationship. Like I said, the reorganization put this NITO group as a dotted line reporting to my group. And when I reached out to the folks at NITO prior to coming here, and I said, how have I been able to help you? They talked about some of the relationships that we've been able to build. Prior to this reorganization, there wasn't communication flowing back and forth. The judiciary is very famous for being very insular, not reaching out to other parts of the organization. And one of the things I've tried to do is break down that wall. When the CSA conferences, the Computer System Administrator conferences happen, I always try to brief the administrators from across the country as to what the AO is doing, not just from a policy standpoint, but more importantly from a security standpoint and what technologies we're looking at. Things like Office 365 that we're looking at now. Changes in our security platform, being able to scan for viruses and ransomware, those kinds of things, and trying to bridge that gap. That's happening at the Computer System Administrator level. I don't think it's necessarily happening at the Defender level. And the challenge is how to communicate that message. I don't have a great answer for that. One point that's been in discussion is maybe briefing the DSAG on a more regular basis so that they would know what's happening. But it is a challenge to get the information out there. But I think there's a lot of good things that are happening.
Mr. Kendall, you mentioned an interesting idea, a scholar in residence. Could you tell me a little bit more about your thoughts on that?
You know, it took the National Academy of Sciences. It took the National Academy of Sciences to basically say that for a lot of forensic science, there is no science. Had there been a scholars in residency program at the Federal Defender Office, I think we would have been hearing that and seeing litigation with those aims years and years ago. And I think that there are tremendous litigators in the Federal Defender Program, and some of the, as some of the earlier panels talked about, some of the CJA lawyers are terrific lawyers, but they simply don't have, there needs to be some sort of a research tank and people looking at the deep data and developing ideas to say, you know, this fingerprint stuff isn't nearly as solid as we all thought it was. And I think we've all learned that our system is a lot more fallible than we thought before DNA. And looking forward the next 40 years, I think if this program has that kind of capacity, it's going to identify some of the problems sooner so we can solve them sooner.
Thank you. Thank you, Judge Cardone.
Judge Gerard.
Thank you. And I want to follow up a little bit with the diversity, Mr. Kendall, and particularly we heard from the panel just before you. We had the public defenders from Nebraska and Kansas and Southern District of Illinois and the Dakotas. I guess my question is, with the less diverse populations, and I'm a judge in one of those in the District of Nebraska, and yet 35 to 45% of the defendants that appear in my courtroom are minority defendants, and yet the judge they see, the clerk they see, the probation officer they see, and most often the lawyers that they see are white, which leads to the comment that you had received from the defendant. And my question is, in the less diverse populations, what type of programs or recruitment would you have to suggest? Obviously, there would be the honors program, and that would provide incentive, but what other types of things do you see? Those are the tough areas that I see to recruit to.
Rome, you can't build Rome in a day, but I think this, you know, I work out of New York City. My team is very diverse. We don't do any representation in New York City. We go where there aren't legal teams who can help on cases. And so I think the Federal Defender Program to do much the same. I think I mentioned in my opening remarks, it'd be good if the Federal Defender Office was more innovative, had more freedom. Why couldn't?
That's the flexibility that you're talking about.
Yeah, why couldn't somebody in New York, why couldn't David Patton send lawyers for a couple months at a time? There are ways to address this, but you just need enough lawyers in the system to address some of these needs.
Okay. And the U.S. Attorney's Office does that on a regular basis. So.
And the private bar does that all the time.
Okay, all right, very well. Thank you. Professor, and I want to be sure I pronounce it, is it Lefstein or Lefstein? I've heard both. So.
I have no authority for it, but I always pronounce it Lefstein.
That is fine. I didn't want to mispronounce your name. A couple of questions, and I was intrigued also by the structure that you proposed of a new federal defense program. I happen to agree with you if there were one that it would be A, high-profile appointees, and two, that all three branches would be represented and be both sides of the political aisle. I think the reason you suggest that is to provide a long-term political buffer, if you would. And in your third paragraph, you said an example of the board could be assembled, and the first was, suppose the Chief Justice of the United States Supreme Court named 5 appointees to the board. Would that include judges?
Absolutely not.
Okay, that's what, and that is the question that I had, because we had obviously Miss Buchanan, Miss Layton were here earlier, and they were they were adamant in what their board makeup was. And my question is, would it be helpful to have judges in any type of advisory capacity or in no capacity whatsoever on a board? And let me hear your thoughts on that.
Sure. Well, I would assume that the members of the board might want to consult judges, but I'd leave that up to them. The standards that have been developed, not only by the ABA, but other groups, are quite clear that neither prosecutors nor judges nor active practitioners of defense representation in the federal courts, whether they be public defenders or panel lawyers, ought to be on the board. The board is a policy-making body, and you don't want to have and should not have people who are active practitioners involved in making policy. Sure, they ought to be heard by the panel or by the commission or the board, whatever we call it. But the people on it ought to have, at least some of them ought to have prior substantial experience in public defense, preferably in the federal courts. I mean, there are other ways that you can enhance the board. You could have the president of the American Bar Association make an appointment. You could have the head of the National Bar Association make an appointment, and you might want to consider having laypersons on it, which is the current situation with the DC Public Defender Service Board.
Okay. And along those lines, the DC Public Defender Service, both of them who were represented this morning, and one of the questions that was posed was would there be any tweaks that they saw in the legislation as it was originally created, and they kindly deferred to you, sir. They said ask Professor Lefstein. He'll be here this afternoon.
Well, that's very kind of them. Since the initial statute was passed and took effect in 1970, there have been modest amendments to it, but I think it has worked exceptionally well. And actually, the law that was passed in 1970, creating the Public Defender Service, was a successor to what had existed for 10 years prior to that, known as the Legal Aid Agency from 1960 to 1970. And it, too, had an independent board or commission and was commended in those standards in 1968, to which I referred earlier.
Okay, very well. Thank you. Judge Carroll, your suggestions regarding coordination between state and federal capital crimes at the early stages for the CHU units, what type of suggestions the type of suggestions that we could make within the purview of our committee? What do you have?
Ideally, the idea would be to have federal defenders represent people in state court. There's some institutional opposition to that, which I understand. There are also a lot of moving parts to it that would have to get worked out. So I think one recommendation would be at least to study this issue and come up with a solution. The second, though, is, and I'll talk a little bit about the Alabama Post-Conviction Project, which has the unfortunate acronym of APCRAP. We're trying to work on that. But the Community Defender Office in Montgomery that has a capital habeas unit created a nonprofit. I was the first president of the board of the nonprofit, and the nonprofit essentially exists to try to fund the activities of the community defender. And what the community defender through the Alabama Post-Conviction Relief Project does is try to recruit lawyers to take state post-conviction cases, provide them with assistance, where appropriate, provide them with federal monies to hire expert witnesses and that sort of thing. So certainly in the interim, the ability to develop those post-conviction relief centers. Now, one problem that they immediately run into is that the way the system works is that the nonprofit has to raise money on its own to reimburse any federal defenders that work on these state post-conviction projects in any way. So one thing this committee could do would be to try to recommend a way that that didn't have to happen, that a federal defender could work in coordinating state court activities without having their time reimbursed. But I think that's a short-term solution, but the long-term solution is a very serious study of how to remedy this problem.
Okay. Very well. Thank you, Judge.
Mr. Khan.
Let me start with you, Mr. Zazo, and I want to ask you a question first about something you said to, I think it was Judge Fisher, it might have been Dr. Rucker, about the cost of standing up a separate system. And forgive me if I'm wrong, but my understanding is that defenders have already their own wide area network. They have data centers where their Lotus Notes servers and DData servers are kept, and they have a bridge between their network and that of the DCN, the courts. And of course, each individual office already has their own network as well as their own servers for their own case files. So I'm failing to understand how there'd be a huge hardware cost in standing up an independent agency.
So in San Antonio, there is a data center, and there's also one in Ashburn that houses their system. So when I was asked that question, I was trying to think what it would cost to move the servers from the Ashburn data center to a separate data center, or they could co-locate in the same data center, which is owned by AT&T. So that's why I wasn't able to give you a cost. I'm not sure how. There's many ways to do this.
Why would you need to move them in the first place? Just because they're co-located in the same location as the courts?
It would depend on what the defenders want.
Okay.
By that question. Because in other examples, there's been cases where just physically within the San Antonio building, there's a bigger cry for being more separate than just being in the same building. So,
Okay, so you're talking about physical separation as
Right.
opposed to logistical
Right.
separation.
right. They're in the same data center in a separate cage within the data center.
Right. So there's really no need to do anything to the hardware to assure its independence?
No, no.
All right. Let me ask you a little bit, because I read your testimony, and of course I've listened to and read the testimony of the defenders, and oftentimes it seems like we're looking at two very different pictures. So I want to try and clarify what I can and understand how you see the system as it exists. You describe your role as head of CMSO as a liaison role, but defenders have stated that they understand you as having operational control, or not operational control, there's a distinction, but having, let's put it this way, that NITOD and the other parts of the defender IT structure are a direct report to you. Is that accurate or inaccurate?
I would say that's not entirely accurate.
Okay, well,
Okay.
explain what you mean by not entirely.
The reason I say that is on the organization chart, yes, they report to me, but they're employees of Texas Western's Federal Defender Office. I don't hire or fire those individuals. So I have no supervisory authority over the people in NITOD.
Well, what does the report mean? You say on the organizational chart they report to you. What does that mean?
That means I meet with them on a regular basis and try to improve the relationship that we have, seeing ways that I can help bring things that are happening at the AO to help the Defender Services Office. But ultimately, they have a veto power about whether or not they accept something.
About
Because
whether or
it's-
not they accept something?
Right. So let's say one of the examples I used was about firewalls, for example. I can't mandate a federal defender uses, at least I'm told I can't mandate a federal defender office install firewalls or turn them on. Okay, I have no control over that office because of the independence. It's separately funded through a separate appropriation from Congress. And again, the people I don't hire or fire them. So I have no control over implementing certain features that could benefit them. That's why I use the term dotted line or advisory.
So let's talk about the software development aspect.
Can I just interrupt for 1 second? I have a question about what you just said. On that issue of the firewalls, for example, because that was in your letter, and I just wanted to follow up. I apologize, Ruben. But is it my understanding, and you know that I'm on the Defender Services Committee, my understanding is that the issue of having, for example, firewalls or those kinds of things is not necessarily an issue of being able to implement, but to have the money to do it. In other words, without the money, no matter how much the AO says this would be a great thing to have, unless somebody gives these defenders the money to do it, they can't do what you're recommending. Am I wrong about
Right, but I
that?
don't think money's an issue there at all.
You don't think money is an issue
No.
for
No,
the firewalls?
like I mentioned in my letter, in the last Defender Automation Working Group meeting, we talked about how to fund those firewalls. I know we can find money. That's not a question. In fact, I'm not even sure how much money is available. I'm sure the money's there. Because security is such a big push right now. After what happened with OMB, we know we need to improve our security. And if one office doesn't have a firewall installed, that jeopardizes the entire network.
Well, okay, so just to, so I understand, so what are you saying it would take if Defenders, because this is one of those things that Ruben was mentioning, or Mr. Khan was mentioning, is different information. What are you saying it would take? I can't imagine any Defender's office saying, I don't want a firewall, let anybody, especially with all of the problems with, you know, cooperating, you know, witnesses and other people trying to get into systems as they are. Why would any defender not come and get the money from you if you have the money and it's just a question of asking for it?
That's a great question, one we debated for about a half hour in our meeting. We can't force the defender office. I suggested certain ideas about how to maybe encourage them to do it, and each idea was shot down because we cannot tell an individual defender office what to do, is what I was told. So I just raise it as an issue of independence that each defender office has. Those computer system administrators don't work for NITO, they work for the individual defender office. So the only people that can control them implementing and installing and turning on and managing those firewalls is that local federal defender.
So let me return to the software development side, and that's something that CMSO does control, correct?
Correct.
So, for instance, the Defenders or DSO has contracts with certain software developers, and those contracts are managed by CMSO.
Correct.
And if Defenders want changes in any of that software, either that would fall within the contract or that would require a modification of the contract, they have to go through you.
Correct.
Right. So let me step back a little bit, because you mentioned on page 5 of your testimony problems with the contracting that occurred in the past. And I want to make sure if I understand what these problems were and when they occurred. So could you answer the last part first? Can you tell me when the problems you're talking about have occurred?
The problems have been occurring for years, to be honest with you. Okay? In fact, two of the last people that left my office, one of the reasons they cited when they left was some of the issues in dealing with the contract issues. Because you have to understand, they're on paper as being the ones responsible for dealing with the company, with dealing with the contract. And when their authority was asserted by someone going directly behind them, they felt they were being put in an unusual position to both speak for the product as well as the defenders.
Well, let me be a little more precise. My understanding is that the main problems with the contract that were complained about occurred during 2013 through 2015. Is that accurate?
Right. Mm-hmm.
Okay, so that was the time of the work measurement study, right, that had
Correct.
been accelerated by the executive committee and the JRC, right?
Mm-hmm.
And of course, Defenders, together with another branch of the AO, decided to use the DData system to manage the data that would be used for the work measurement study. Is that right?
Correct. Mm-hmm.
And that required a large number of changes to the DData system, some of which may have been within the scope of the contract, some of which may have been outside the scope of the contract, right? Now, all of that occurred after the reorganization. Is that also right?
That's correct.
Okay, that's my recollection is the reorg occurred roughly,
June of 2013.
yeah, and with Defenders starting to feel its effects sometime around October.
I think that's when sequestration took hit, yeah.
And when did you come on?
I came in November, end of November,
Of 2013?
2013.
And so that's the time when changes were being looked at and beginning to be made even later. So your group was in charge at that point of the contracting?
Correct. Mhm.
And now I know you were dealing with a lot of issues because you manage not merely the Defenders, which is a relatively small piece of your portfolio, but the software development for the clerk's offices, for bankruptcy, probation,
district.
pretrial, all of those, right?
And probation, yep.
All of those of which sort of dwarf Defenders in size.
In terms of number of users, probably.
Yeah.
I mean,
Can you tell me what percentage of your time were you able to focus on the contracting issues for Defenders over that period of time?
I didn't really spend much time because I had people, I was brand new to the organization. There were already people in place that were managing that contract.
Okay. And, okay, that's what I would have expected, but I wanted to clarify that. But there were CMSO employees in place managing those contracts,
Correct.
dealing with these
Right.
issues, right? Now, we talked about D-Data, and I want to talk about one other system very briefly, and that's Dismas. And you mentioned them both in your written testimony, and I notice you say that defenders are enthusiastic about D-Data, and you do not offer the same endorsement about Dismas. Is that an accurate observation about your testimony?
Yeah, I would say so, and that's because Dismas is a system that I would say is in flux. You have to realize Dismas is a data warehouse that takes data from the HR system, from eVoucher, from the facilities management product, and also from D-Data. And all that data comes in, and through that Dismas system, we're able to generate reports that we need both internally as well as for reporting to Congress. All those systems I mentioned have been redesigned by the AO in the past 10 years. We have a new financial system, new HR system, eVoucher's new, and as a result, we still have this old system, and the interfaces that connect to it aren't what they could be, I would say. And just like any investment, there comes a time when you need to make a decision about do you continue to invest and modify something you have or move to something new. And I think that's the case with Dismas.
And Dismas itself is an old system, isn't it?
Right.
All right, and now there's been a new iteration, but that was not a complete ground-up redesign.
The new
right?
version was mostly cosmetic, changing from one language, I forget the old language, to Java.
Okay, and there were significant problems in accomplishing what needed to be accomplished, even in that, making those changes because of the antiquated nature of the system.
That plus being able to really look at the data quality coming across.
Okay.
Because we don't have insight into the Defender data system. We
Yeah.
can't tell if the data
And-
coming to
and-
Dismas
yeah.
is correct.
And that's an issue I wanted to explore. I mean, one of the problems, of course, is that Defender is the information, some of the information that gets transmitted to Dismas is, of course, highly confidential information, and it's held with even more confidential information. And so you, as a non-Defender employee, simply can't look at it.
Correct.
Right. So the people who actually have operational control over it have to be separate from you as the management control over it, right?
Correct.
Whereas if it were a unified system, if someone within the Defenders had that management control, they could look into the actual data and fix these problems directly when they occur.
Yeah, if it was designed that way. I just want to point out, though, that the data coming across from Defender data into Dismas is summary data. It's not case information.
No, I understand. I'm saying that, but the data that's sent across is itself, before it's sent across, located with, housed in servers that contain highly confidential information.
Right.
Attorney-client confidential information, right? And so that's a problem that the reorg itself created by moving the management out of Defender Services and into a separate branch that was responsible to all of the courts, correct?
But before, it was being transferred over to DSO. So depending on where you draw that line, it was still being moved over to the AO.
Yeah.
Not
But
CMSO, but to
But Defenders had a
DSO.
very different view about DSO versus CMSO, correct?
Okay.
And DSO didn't have a responsibility to the entirety of the courts, but
that's
to
true.
the Defender system. Okay. I want to turn to eVoucher because you mentioned that, and that's been a big subject both for the committee as well as obviously for the program as a whole. The committee itself has often had questions about what kind of data we can get out of eVoucher and how accessible it will be. And the program as a whole has had questions about what sort of access we can get to data because it's important for planning and managing the program. And you know, my understanding right now is basically the eVoucher data is not something that Defenders or the Defender Services Office has any control over or direct access to. Is that accurate?
I do not know. Because the reason I say that is I know on the product backlog, the new features that need to be built, there's requirements coming from the Defender community. I do not know what's been built right now.
Okay, are you aware of any reporting that Defenders or DSO or judges on the Defender Services Committee can pull upon directly without asking for authority to someone else, from someone else?
I'm not sure.
All right. Now, I should say, you and I have talked before, and we've talked about some of the suggestions that might help sort of bridge these gaps, right?
Right.
And hopefully we're going to implement some of those in the future.
Correct.
Yeah, okay. I want to leave you alone for a little bit. As I said, I don't want this to feel like a congressional hearing. But so I'm going to turn to you, George, and I've got a question for you, and this is sort of a bigger picture question. You talked about moving the defenders into kind of a bigger world. And, that's very appealing. It's very appealing to sort of take people who are well-resource enabled and have them look at some of the bigger issues that affect the criminal justice system. But of course, we've got some bad experience with legal services agencies that were focusing on big issues as opposed to the sort of protection of being involved in the day-to-day case issues. And I'd ask if you could comment on that as we look at possibly moving this to some relative degree of independence. Would focusing the organization on big picture issues put us more at risk politically?
I'm not saying refocus, I think, a huge change of direction. I'm saying that given the way the world works, there is a need, I think, within your program to have this added capacity that would be of service to your primary function, that's litigation. That you would be ahead of where you are now in identifying, if you had the scholars in residence, if you had something like that, you could get ahead of, hey, I think there's something wrong with this, that, or the other thing. You wouldn't have to wait for somebody else to develop that data. This program would have the ability to develop the evidence to support that. I don't think that makes the program a lot more controversial. Legal services, as I understand it, where they had problems was that instead of just doing divorces and other things, they were filing major lawsuits on a variety of things. And so I think what I'm talking about is to really get into where are there some real problems in the administration of criminal justice that the federal defender is going to have to deal with, and just to get at it sooner, is my point.
But then to deal with it in the context of individual client representation?
Absolutely. For example, on this 101 disparity, there could have been litigation on that sooner than there was. There are a number of issues. Had, I think, the Defender program been in the position to really dive deep into the data and and really build a case of what's wrong with this. I think that there was effort made to litigate issues around that early on that didn't have that kind of support, and thus they didn't go anywhere.
So let me ask you about one other funding-related issue, and I don't know, Professor Lefstein or Mr. Carroll, you may also know something about this, and that's, this was, I can't say before my time, but it involved the issue of 2254s, which is not something I've ever spent any time with. And that's the defunding of the resource centers. And you know, the sort of bugaboo for defenders as they talk about independence is the loss of funding without the protection of the judiciary. And of course, we know that that loss of funding, that defunding occurred, and in fact occurred while we were under the protection of the judiciary. So I wonder if anybody would offer a comment on that and how that might affect anybody's thoughts about whether or not, one, the advisability of independence, and two, whether or not the judiciary's protection when Congress really wants to come after you is as important as it might otherwise seem.
If I could say real briefly, because I was watching that very closely at the time, I think that instance shows that the judiciary doesn't have as much authority as I think some of the defenders would like to think. Richard Arnold, Judge Arnold from the Eighth Circuit, had the duty to pitch the judiciary's budget that year, and Phil Graham, the senator from Texas. It was a very short hearing where Judge Arnold came, he was prepared, and the senator said, look, your budget's fine, but your resource centers are toast. And that was basically the end of the hearing. I don't think the Defender program is in worse shape or less able if it has a lobbying group that can reach out to a lot of other senators and to try to deal with that problem. It might not work any better. You're not going to win all your issues in Congress, but the federal judiciary did what it was supposed to do. It defended the Resource Center program, but it didn't have a chance because the senator was very determined to deny authorization for that program to continue.
And I was in the Middle District of Alabama at the time we lost our Capital Resource Center, and it was for the reasons you suggest. They were too successful and got the ire of Congress. That's why when I was suggesting some sort of an approach to the allowing coordination, I'm confident if we went to Congress today and said, oh, by the way, we want you to fund federal defenders in state post-conviction, we'd run into a stone wall. So I think there's thinking about middle grounds that don't involve that is where we really ought to go with this. There needs to be some sort of coordination. In the current political environment, it's hard for me to believe that Congress would say, oh, sure, that's a really, really good idea. So I think, but it's a serious matter that when a program, particularly in a controversial area, is successful, it attracts the interest of certain kinds of senators and congressmen.
Can I ask you, you know, one of the things we've talked a lot about is what can be done with changes in statute, changes in policy, that sort of thing, and what can be done right now, this minute. Do you have, and I listened to Christine Freeman's testimony very carefully and was moved by it, and one of the things I think about is there anything we can do right now without statutory change to allow defenders to better work on those 2254s?
You know, I think one change would be not to have them reimburse the federal defender for their time. So that would allow you to create these essentially post-conviction resource centers within the federal defender office without the need to create this nonprofit that you have to fundraise for. So now mechanically how that will work within the bureaucracy of the Defender Services Office, I don't know.
Do I have time for one last question?
Yes, go ahead.
So this is back to you, George, and I'm asking you, and also in anyone who's done the sort of congressional outreach over a sustained basis. One of the questions I asked earlier, and I kind of pose it again, is if defenders had some independent identity, either within or outside of the judiciary, what's the sort of presence they need? You know, you look at the AO and they've got a dedicated staff who maintains relationships with congressional staff, who's there presenting regularly to the members when they get an opportunity to do so. Is that necessary? Is some lesser permanent component necessary? What do you need to actually build, develop, maintain the relationships and do the advocacy you would need to sustain an independent program?
Well, you know, I think from the sequester, there was some contact between members of Congress who were just interested. You know, what is this going to, how's this going to affect the federal defender program? And I think the lessons from that was that this is a great brand. It didn't matter whether you had a D or an R or an I label who you went to talk to. The federal defender program has an excellent reputation across Congress. The second thing is, unlike other expenditures, this is a necessity. This is not, can we buy a few less planes or whatever this year and save it to next year. The courts have to operate. And when you take the entire judiciary budget, and then when you subtract out the federal defender budget, it is a pittance with regard to the entire federal budget. So there are I think there's a lot of hope that unless things got really, really dire, that because of that this is a fundamental need of government to keep the courts open and see that indigent people have representation. There are many good arguments that I think the defenders, with a little bit of help, could sell each year. However, there would need to be capacity when there is trouble to be able to bring in lobbying shops that really have access and can really get this message out to the key people in Congress and in the executive branch.
Professor?
I was just going to say that the federal judiciary can continue to be very supportive of the Defender program if it chooses to do so. In the early years of the Public Defender Service in D.C., there were examples in which the judiciary was very supportive of the program. We appeared annually before the House and Senate district committees, which I assume may still be the case, and the judges from the Superior Court, the trial court in D.C., were quite supportive of the actual budget of the D.C. Public Defender Service. I also wanted to say in response, if I may, about the Scholar in Residence program, that we had started something like that at the DC Public Defender Service in our early years. And we had professors come in, typically at no cost, although sometimes you might incur costs, but they were often specialists in criminal law and procedure with some prior defense experience who had a sabbatical. And we would bring them to the office, and you could do something like that on a national basis, probably. Moreover, if you're going to try to recruit minority students, one technique is to bring them in after their second year, and I'm speaking now as somebody who's been involved in legal education. But if you bring people in after their second year of law school, and you could make it even a national program for the summer, the likelihood of retaining them after graduation is sharply increased as they understand what's involved in federal defense. So it's just a thought that these are difficult issues, but they're not impossible of solution.
Just one quick follow-up on that. One of the difficulties we as federal defenders have is that there are no misdemeanors for young lawyers to cut their teeth on. And so a lot of defenders are highly reluctant to hire lawyers with no experience, no trial experience. If we were to put that sort of effort on a concerted basis nationwide into the sort of pre-graduation recruitment internships, in your view, as somebody who's spent a lot of time with law students, does that pay dividends down the road in bringing those people back if we weren't going to hire them right out of law school? Is it something you've got to be able to follow through with a job after graduation?
Well, potentially it does, but you're right, there is a real difference given the absence of the misdemeanors, and they're not going to come in under a student practice rule and be able to perform under the tutelage of a lawyer between their second and third year. So I think it's a little less saleable, and I hadn't thought of that when I made my comment.
Thank you.
Yeah, I mean, Ms. Kendall, I agree with you in reference to diversity, and I've talked to a lot of law students who have a real interest in doing public defense work, but one of the big impediments is...
Can you speak into your microphone? I'm sorry.
One of the big impediments is law school is so expensive now, and many of the students are coming out with these huge debt obligations, and they don't have the family support to help them pay those back. So going into any type of public service work becomes a real difficulty. So, I mean, how do you overcome that?
Well, Judge, I think there have been discussions about having loan forgiveness programs so that, I can tell you, when I was at the Legal Defense Fund, there was a while the only people we could hire because of the salary that we paid were people who came out of law school without any debt. And that was we did not like being limited to that pool of law graduates. But it seems to me that's something that Congress is going to have to address, that if you devote a certain amount of time if you go to certain law schools, if you devote 10 years to public service, your loan is forgiven. You go to Columbia, you can't get married, there's a lot of disqualifiers, but you can get rid of that debt and be in public interest. But a lot of law schools you can't. And there should be, like if you're a doctor and you go into the public health service, I don't know how long you stay, but once you stay that time, all your debts are over. And then we're going to have programs like that to encourage and to retain people who have, which I see regularly, $250,000 in debt with college and law school.
Mr. Zezo, I don't think you directly answered this question, although I think there have been some questions that maybe touched upon it. But one of the concerns that we've had expressed to us in reference to the current IT structure at the AO is that the confidential information in the system is not as secure now as it once was under the old system. Do you agree with that assessment?
I don't agree with that at all, Your Honor. Are you saying that because of the new reorganization, the way the organization is structured now? It's less
Yes,
secure?
that's what we've heard, that because it's now incorporated with the other.
No, that's not true, because the Defender data still resides on servers in NITODE and run by the same people in the NITODE group. No one in my office, in the regular case management office, excluding NITOD, no one else has an account on the Defender data system. So the same people that managed it before the reorganization, the same people managing it today.
Can I follow up on
Sure.
that? It was my understanding, and correct me if I'm wrong, Mr. Zazo, but you made reference in your testimony to what we heard, which was called like a hack or something.
Right.
And it was my understanding that the concern was that the AO, and I'm not privy enough nor astute enough in IT things to be able to say it correctly, but it's my understanding that there were being tests run by the AO, and the AO was attempting to run a test, and when they were running the test, they were going into data that was in the NITOD system. And so they were essentially trying to get in or messing around in there, and NITOD wasn't aware of it. And so it's that kind of concern that people that aren't part of the defense function, that are part of the AO, I understand, but that aren't really part of the defense function, because of that relationship, have the ability to either try or to actually, if they figure it out, get in there so they can run tests like that.
Your Honor, that was one of the areas I wanted to correct in the testimony.
Okay, and that's,
There's
but I
actually,
think that's what-
I can provide you, if you want, the email where one of my employees requested an account in the test environment, not the production environment, but the test environment. And the reason they needed that account was so they could verify that the data coming from Defender data over to Dismas was coming over correctly, to work on that interface. Now, when you develop software, you have a development environment, a test environment, and a production environment. And the reason why you have a development and test is that's where you can make all your mistakes. That's where you write your code and then you test it and test fine to see if it's working properly. We're getting criticized for not having Dismas function properly, but we can't even get the data over to see if it's coming over correctly through the interface. So one of my employees requested through an email access to the test system so they can work on that interface. It was reported to this committee as a hack, and it was one of the things I wanted to correct.
Okay, so
That's not a hack.
that's what you're making reference to.
Correct.
And what Judge Walton's referring to.
Okay.
Okay.
Can I clarify, because I want to make sure we understand, what really happened was a miscommunication, right? That your people had requested access to the test area, but hadn't informed NITOD or Defenders, and they drew an incorrect conclusion that there was an attempt to get to the actual data, right?
Mr. Khan, I can provide you with the email where we requested permission, so I don't know how that would be.
You requested it from Defenders?
From the NITOD group, from the
Okay.
test environment, not the production, the test environment.
Okay, all right, then, that's what I'm trying to clear up. So request went from CMSO to NITOD for access to the test
The test environment, not production.
And that's,
For
to
the
your
purpose of
knowledge,
working
and
on
I
the
wasn't
interface.
involved in this, but to your knowledge, that was the only incident that gave rise to concern?
Correct.
Okay, thanks.
And, I'm sorry. Judge Gerard pointed something. Can we have a copy of that email, just so that we can document?
Sure.
Great.
Happy
thank you.
to.
I'm sorry, I didn't mean to interrupt.
I'm
you.
fine, thank you.
Okay. How about anybody else?
I have a quick question for Mr. Kendall. On the idea of lobbyists to lend and assist if there is complete independence on Capitol Hill. So it's been a long time since I've worked at a big firm, but I'm going to pick a $800 an hour number. So as what my guess is as to what the lobbyists would cost. So could you tell us how that could it be reduced rate, but are the big firms going to allow their hotshot lobbyists to reduce their rates? I mean, the rate now for the CJA lawyers is $129.
Obviously, there are people who are lobbying who bill at four figures. There are also.
So my 800 estimate was low.
Well, for some, it was low, but depending on who the client is.
Right.
But that's, the last part's the important part, is depending on who the client is.
Right.
There is also there are various rates, and I think what you have here, this is really advocacy in support of the Sixth Amendment defense function. And while there might be 80% of the law firms who are not very sensitive to that, you only need a few who are. And I would be stunned even knowing how important some of those lobbying shops are to the bottom line of those law firms, that they would not devote a considerable number of hours at a vastly reduced rate to handle this contract.
It's a really creative idea, which is why I wanted to ask you a couple questions about it. And even those level of lobbyists, even though they go to Capitol Hill and they represent major corporate clients, you think there's a pocket of those persons who would say, well, today it won't be Exxon, today I'll advocate on behalf of indigent defense.
Because the amount of money you're talking about here is minuscule compared to what they're lobbying for on contracts and other things. What you're getting, if you have to pay $800, you don't need to pay the whole contract. You need, in my firm, there are 2 former senators. You would not need them for hundreds of hours. You might need them for 5 hours because it's access. There are a small number of people on the Hill who decide this budget every year, and that's what you need, access at the right time.
Interesting idea. That's all the questions I had. Thank you.
Professor Gold.
I cannot tell you what a joy it is to be on the other side, finally being able to ask Dean Levstein a question, and Mr. Kendall for that matter. I don't know which one of you it was who said in your testimony or earlier questioning that it was an inherent conflict of interest to have defender services or the defense function underneath the courts. And the committee has heard the expression conflict of interest before from people who come and testify before it. I'm wondering if you could elaborate on what you mean by conflict of interest in this context. And I'm presuming I'm not putting words in your mouth. I can't remember which one of you said it. But could you elaborate on what you mean by conflict of interest?
Well, I taught ethics for a number of years, and one of the most important rules on conflicts is 1.7, which deals with when you have a personal interest conflict. And I hadn't really thought so much about it until I was looking at the impact of sequestration on the defense program in the hands of the federal judiciary, and the cut of positions and the reduction of the fees to assign counsel. I think it was a $15 reduction. And I suddenly was clear to me that on the one hand, the federal judiciary has a personal interest in protecting its budget, and at the same time is also trying to support the Defender program. And suddenly you had this very clear collision between protecting the Defender program and protecting the federal judiciary's budget, and the clear winner was the federal judiciary budget. That, to me, is a serious conflict. And I think that conflict plays out in other situations. Certainly in instances of the state courts, I've seen it, and I perceive it to be present here too when it comes to approving vouchers or approving monies for experts or investigators, because there's a concern about the expenditure of federal funds and how it ultimately looks to the bottom line of the federal judiciary's budget. I think there were citations in one of the statements I read about not funding capital cases, and this was a memorandum from a judge, not funding capital cases as high as some defenders might like. And so, I mean, this is an inherent problem, it seems to me, where you have certainly, by and large, very well-intentioned members of the judiciary who have been, by and large, for decades supportive of the Defender program, but when the situation really got tight, and it was really an issue of sequestration, but it plays out in other circumstances quite irrespective of sequestration, where there is a conflict between looking out for the federal judiciary's budget that supports judges and everyone else connected with the judicial function, and this defense function, which is really very different than the judicial function. And as I said in my statement, no one, and indeed the Prado Committee said it back in the early 90s, no one would seriously consider having the federal judiciary oversee United States attorneys throughout the United States. And if suddenly somebody introduced a piece of legislation like that saying, well, the federal judiciary has the defense function, let's give them U.S. attorneys too. Why? Nobody would take that seriously. People would dismiss it out of hand as a perfectly preposterous idea. And yet we sit around talking now, more than 50 years since the Gideon decision and more than 50 years since the original Criminal Justice Act, where the Congress suggested it ought to be a temporary arrangement, and we still have the judiciary in control. And to my way of thinking, even though there's an uncharted sea out there and nobody can predict it with perfect knowledge about how it will transpire and how it will go down, it seems to me a bullet that needs to be bitten. And finally, it needs to be an independent authority.
Thank you. George, let me turn to you.
I want to say that I did not know he was going to ask me that question.
No, he did not. We can
And I
stipulate to
didn't know
that.
I'd get so worked up in answering.
But I never get in your way, Norm, when you get worked up.
I'm sorry you stopped.
George, if I can turn to you for just a moment. Your idea about the lobbying, it's the first time I think the committee has heard an idea like this. And I think to some areas it may seem, I'm going to go out on a limb and say fantasy. How is it that a New York or Washington, D.C. based law firm is going to decide to take on something like this? And for those who are in Washington, D.C., I think it may be a little easier to understand the nature of the pro bono practice there and why a firm might agree to take on something like this. But let's be as realpolitik as we can. What's in it for a law firm in deciding to put, you have what, Trent Lott at your firm?
Yeah.
Why would someone agree to lobby on something like this?
On the state level in various states, on the state level, there are law firms that lobby for indigent defense in states. If the the federal defender system was moved out of the AO, and it had to defend its budget, it would need a plan every year to go and, just like what, as PDS described this morning, more money here, new tradition. You would want, I think, lobbying help. I think that some law firms would be honored to ask to do that. Just like I have to make 40 phone calls to get some DC firm or New York firm to take a capital case at the district court level. I have to make one phone call if cert is granted on a case, and would you like to argue this case in the United States Supreme Court? What we're talking about here is really like that. It's not exactly like that, but it's close to it. I could say at my law firm, we are going to make sure that the Sixth Amendment, the agency that has the obligation to carry that out, has the resources it needs. We are proud to have that responsibility. So I think that there would be, there are all kinds of people from, there are people from Congress who fought on Appropriations Committee for these budgets, who are now working as lobbyists. I think that there would be even choices to be made about which firm, who is it that we need to really be able to reach this chairperson or that chairperson.
Mr. Kendall, now that we're discussing this, the largest firm in our district, Morgan Lewis, they routinely take cases from a pro bono panel that we have in the Eastern District of Pennsylvania for representation for prisoner civil rights cases. So people have the same reaction as I'm having to this idea. Well, Morgan Lewis is going to represent a prisoner in a civil rights case, and there's a pocket of folks there who, as you said, proudly do it.
Right, not everyone does it, but there are, and even on it's never been easy on the capital cases, but if you make enough phone calls, you can find somebody who'll take those cases on that are 1,000 miles away, that are in, as John was saying, that are in a heap of trouble because they've gotten through the state court system and all the evidence you need to develop the claim is not in. That's a tough assignment. There's still law firms, if they're approached correctly, who will say, I'm not going to look the other way. I might not win this case, but I'm surely going to try. And let me just, if I could, John, just make one add-on to what Norm was saying. Norm's talking sort of wholesale. Let me talk retail. I think that this current arrangement puts the judiciary in a difficult situation in cases. I've had cases where I've had to go in chambers and talk about a case budget, where I was told before I went in, don't tell that judge what you need because he has lunch with the prosecutor every day. Not federal judges, state judges. I couldn't go in and advocate honestly for my client. I've had other cases where I feel like because I had this kind of access to the judge about the theory of our case, I was in better shape than the prosecution was. Because going into the case, the judge had a better understanding of some of the key legal issues. Because I'd had this ex parte opportunity, which the only way to do that is ex parte. And the prosecutor doesn't have it. The prosecutor doesn't need to. But there's just no necessity for this at that level. There's somebody else who the indigent can go to and say, this is why I need this money for these experts. It doesn't need to be the judge. Judges are critical players in our system, but they don't need to play that role. It's only the indigent defendant who has to go to the judge and to reveal these confidences to be able to have their day in court. We can move that function away from the judiciary, and I think everybody wins, including the judiciary.
If I could follow up on that, one of the things the committee has heard from and seen in some of the evidence before it is tremendous geographic disparities in the use of experts by panel attorneys and in the level of zealous representation across all areas of defense. There seems to be local legal cultures that are different in particular areas versus others. If the courts were to become more independent from the defense function, how is it that you see some of those regional local cultures being worked out, if at all? Is this independence going to help in improving the level of representation in areas where right now it's substandard?
I mean, I can volunteer an answer. My guess is it would make an enormous difference. You would have a mechanism set up within the new program and some guidelines and standards for approving investigative assistants and experts, and there would be, the only impediment being an absence of adequate funds, there would be a receptive audience to it by those in charge because they would review it perhaps, or they put it into a budget, and only if the budget was used up would you go and seek perhaps special assistance. But you're talking within the defense community. You're talking, but I do think you would probably budget for it in the first instance, given the national program involved here, and only if funding was running short would you then go somewhere else for it. I mean, PDS has funded experts and investigators for years. It's in their own budget, and there are some other defense programs around the country that does it in that fashion.
If I could just raise I thought that your professor, your proposal regarding a structure that conceivably could be in place that would have some supervisory responsibility for this separate entity, because obviously there's going to have to be some entity that's going to be in charge and responsible for that. And, we've talked, at least some people have talked about the Sentencing Commission as an example. Well, there's a problem with that because look at what is happening to the Sentencing Commission because of, I believe, some dissatisfaction with some decisions that they've made or recommendations they've made. So what's happening is that the commissioners are not being appointed, and I think they're down to 5, and if there's not an appointment made soon, they become ineffective. And I guess while I agree with the idea of independence, I just feel that there is enough potential opposition to the role of the defense function within our system, which I know is critical, that I think maybe some congressional members don't think it's as critical despite its constitutional mandate, who would engage in nefarious things that would undercut the ability of that independent entity to operate.
No one can give you absolute assurance that it will work out perfectly. My personal view is there are enough reasons to think that it would, and that the current situation is simply not acceptable. That's my personal view of the matter. I think it violates basic notions of how to structure the defense function. And I think people who have looked at this know that it violates the way in which defense services ought to be delivered. And we will need to work hard, as I think George's comments suggest, to make sure it functions as well as it possibly can. But as long as you say you're concerned that those fears might be realized and therefore we should leave the status quo alone, this issue will fester for another 50 years or longer, because nobody can guarantee that you'll have exactly the outcome that you want.
Can I just make one further comment on this? I think, you know, the big private bar is largely abandoned. Has largely abandoned the federal or the public justice system. There are lawyers in every law firm who don't remember the last time they went into the federal courthouse or the state courthouse because they do international arbitrations, they do all kinds of other things. And this is not a criticism of them, but it's just reality. It's hard to find people with stature now who could say to these law firms, you have got to re-engage for us to have a real effective system. You can't just ignore the public justice system. It's too important. I was hoping that President Obama and Eric Holder would call the big firms to the White House, just like John Kennedy did in 1963, and said, we need your help in enforcing the 14th Amendment. The result of that one meeting are still being felt. The law firms with the best tradition for providing pro bono services are in Washington, D.C., because some of the people who went to that meeting in 1963 became senior partners, Lloyd Cutler and others, who said a basic core function of a law firm is to not look another way and make sure our public justice system operates effectively. And I think one of the powers that the judiciary has that it doesn't use is to reach out to the big bar and say, we need your help. When we were swimming in capital cases in Florida and Alabama and Georgia in the late 80s, thank goodness John Godbold was the chief judge of the 11th Circuit. He said, how can I help? And he got together with the chief judge of the Florida Supreme Court and the Attorney General and wrote to every major law firm in Florida and said, where the hell you been? That generated about 40 law firms that took cases. And most of those firms did a pretty good job. But more importantly, it brought them back in, and then when they saw what the problems were, they couldn't believe it. And the judiciary has the power here that it doesn't use often enough, frankly, to reach out to these big law firms and say, we need your help. Not that we need $50,000, but we need your involvement.
Go ahead.
I just wanted to make a quick comment, building on something that George just said, that one of the things a new defense program could do is mobilize law firms all over the country to support the new defense program. By virtue of writing letters, maybe creating an advisory committee, they could be highly influential. I mean, I just think there are ways to get the job done if one thinks about it creatively.
Yes, Ms. Rowe.
Mr. Sazo, I have a question. And I have to say that I've read your statement and listened to your testimony today, and I really hadn't intended to ask any questions, but as I look at your statement even just one more time, I keep coming back to the last page of your statement and the second to the last paragraph. And it says, "Let me end by saying, contrary to other testimony provided to the committee, the CMSO is providing great value to the defender community." And I can't help but remember that the testimony that you're referring to has to be the testimony of the defenders, a number of defenders, who have sat before us all over this country and said that they did not think that CMSO was providing value, and actually that they thought it was damaging the program. So I guess my question really goes to the issue of, if the constituency, the people that you're supposed to be providing a service to, don't believe that they're getting any value from the service, first, that's something this committee should be concerned with. But second, what can you do differently at the AO to serve that constituency in a way that they could actually recognize or start to believe what you're saying is true, that there is a value?
You know, before I use the word insular, and I really believe the judiciary is a very insular group and has been reluctant to look outside for new ideas. I reached out to someone in the NITO group, the chief of the NITO group, and I asked him, can you tell me how I provided support? And he gave me some points. He said, in terms of staffing, CMSO has worked on several occasions to support efforts to get additional resources for NITO. On purchasing, CMSO was instrumental in assisting with purchasing software and hardware and supplementing funding received in FY14. Through the use of our SuperCard, which is a credit card with a value over $3,000, we were able to quickly purchase items that would have normally taken months. On relationship building, he wrote, and these are all points that he wrote, CMSO has been active in trying to get NITO to presence at the AO. For as many years as I've been here and have been to the AO, it wasn't until the past year or so that I've been able to walk the halls of the Thurgood Marshall building and actively have conversations with DTS, the procurement division, and other offices. We're now seeing more involvement and communications with other groups and at least get a seat at the table as decisions are being made. Awareness of AO initiatives. One of the longstanding issues is that NITO has faced is not being aware of major IT initiatives within the judiciary. NITO always learns about things after the fact, and in many cases after the defender CSAs were notified. This puts us in an awkward position within the community, as we've always been seen as the group to be on top of major judicial initiatives. Through CMSO, we've been able to get advice, advance notice of many judicial undertakings, and at time have allowed us to collaborate with other people. And training. A little while ago, CMSO was able to get NITO management involved in Agile training. This methodology and information obtained from this course were able to help me and my staff develop processes and procedures to improve NITO operations. So when I say, the value I can provide, I can only provide value if I'm seen as a partner. And I think that's the major change that needs to happen. I'm not the enemy in the sense that I'm trying to take over, control these systems. I'm fine with NITO running the systems. I'm fine with the relationship we have now. But I would love NITO to be able to, the defenders to be able to look beyond the defender community for ideas. There's a lot of great innovation happening in the judiciary. There's been mobile applications written by other offices in other federal districts that I've actually had them come and present to DSAG. I don't know if you remember, Ruben, I think it was about a year and a half ago, there was a mobile app that probation officers had developed that allowed them to download their clients, go out and visit them. They would track information on them, because they would do the chronos with it. They would track the mileage, and at the end of their trip, they could upload all that to their system. Now, I know this developed for the probation officers, and that was the reaction I got from the defender community. But then someone said, those are the same people that we visit. And why can't that application be hooked to a different database and provide value to the defender community? So I think there's a lot of things that I could be doing that I have been trying to do, but we're still stuck in this whole fight over who can see what.
Well, the thing that comes to mind when you say all those things is that their access, those folks that you talk about, their access is now dependent on the fact that they're connected to you and connected to CMSO. No, let me speak, you spoke. So I'm just saying to you that that's what it sounds like. It sounds like, yes, you're expanding their access, but it's because the defense didn't have access before. They were just kind of stuck over to the side. But now that it's part of CMSO, they get the access. The second point that comes to mind when you're saying all those things is you're talking about NITOD. I'm talking about the defenders. The defenders are the chiefs of all of these 91 offices or 81 offices throughout the nation. But it's the defenders who don't see the value. So I guess my question is more to, how do you make the defenders, if in fact you are providing value through being in this connection of CMSO and breaking down the operational silos, as you put it, how do you get the defenders to see this value?
I think the answer comes from better communication with the federal defenders. Up until now, my only communications has been through the NITO group and the DAWG, Defense Automation Working Group. That's been my communication channel. Love to be able to change that. Love to be able to come before you in a year and say, you know, here's changes I've been able to make because of the access I've been able to have. But up until now, that hasn't been something I've been able to have.
Thanks.
All right, well, and we're pretty much right on time for a change. I want to thank all of you again for being here and for taking the time out of your busy schedules to be here. And I know a number of you had to arrange and rearrange, so thank you for all of that. If there is anything you would like to add, because once we start discussing, there are other issues that come up, please feel free to give us any further submissions that you think will address some of the things we've talked about today. And I appreciate your time. Thank you very much on behalf of the entire committee. Thank you. All right, and we need to meet real briefly as a committee.